Question 26. Who signs a deed of reconveyance? A. Trustor. B. Trustee. C. Beneficiary. D. Grantor. Correct answer is B. Trustee. A deed of reconveyance is used to release a lien on a property when a loan secured by a deed of trust is paid off. Here's how it works. Trustor, borrower. The trustor is the one who originally gave the trustee the right to hold title in trust as security for the loan. Trustor don't sign the deed of reconveyance, they receive it. Trustee. The trustee is the neutral third party who holds the title to the property while the loan is being repaid. Once the loan is paid off, the trustee executes the deed of reconveyance, effectively transferring the title back to the trustor. Beneficiary, lender. The beneficiary is the lender who is receiving the loan payments. While the lender notifies the trustee that the loan has been paid, they don't sign the deed of reconveyance itself. Grantor. In a deed of trust, the grantor, usually the borrower, is the one granting the trustee the right to hold the property in trust. Since we are dealing with a deed of reconveyance, the trustee is now the one granting the title back. Question 27. The real estate professional who tries to find a buyer for the property but is not a listing agent is called an A. Cooperating agent. B. Agent in fact. C. Ostensible agent. D. Non-listing agent. Correct answer is A. Cooperating agent. An agent in fact is someone who is authorized to act on behalf of another person, the principal, in specific transactions. This authority is granted through a legal document called a power of attorney. The agent in fact can make decisions and sign documents on behalf of the principal, but only to the extent specifically outlined in the power of attorney. An ostensible agent is created when a principal's actions or inactions lead a reasonable third party to believe someone is their agent, even without a formal agreement. The third party must reasonably rely on this appearance of agency when dealing with the supposed agent. The principal can be held liable for the actions of the ostensible agent due to creating this impression of agency. Example: a real estate broker allows a salesperson to use the brokerage's letterhead and business cards, even though the salesperson's license has been revoked. A third party, unaware of the revocation, deals with the salesperson, believing they are a legitimate agent of the brokerage. The brokerage could be held liable for the salesperson's actions as an ostensible agent because they created the appearance of agency. A non-listing agent isn't a formally defined term in real estate. Non-listing agent generally refers to an agent who is not the listing agent for a particular property, but is involved in the transaction in some other way. The most common non-listing agent scenarios is buyer's agent, cooperating agent, or selling agent, dual agent. A cooperating agent is a real estate professional who works with the listing agent to find a buyer for a property. They are typically associated with a different brokerage than the listing agent. They cooperate with the listing agent to complete the sale. Question 28. Which of the following would not terminate an escrow? A. An order by the broker. B. An agreement by the parties. C. One of the parties being unable to meet a contingency of the sale. D. The destruction of the property that is the subject of the escrow. Correct answer is A. An order by the broker. A broker does not have the authority to unilaterally terminate an escrow. Escrow is a neutral third party holding funds and documents related to a transaction. It can only be terminated by B. An agreement by the parties. Both the buyer and seller must agree to terminate the escrow. C. One of the parties being unable to meet a contingency of the sale. If a condition of the sale, like financing or appraisal, is not met, the escrow can be terminated according to the terms of the agreement. D. The destruction of the property that is the subject of the escrow. If the property is destroyed, the purpose of the escrow is no longer valid and it will be terminated. Question 29. The 1% service fee on FHA loans is paid by the A. Primary lender. B. Secondary lender. C. Borrower. D. Seller. Correct answer is C. Borrower. The 1% upfront mortgage insurance premium, often referred to as a service fee on FHA loans, is paid by the borrower. It's typically rolled into the loan amount. Question 30. The method that an appraiser would most likely use to appraise a concert hall is the A. Cost approach. B. Sales comparison approach. C. Capitalization approach. D. Value approach. Correct answer is A. Cost approach. Concert halls are specialized properties with few comparable sales. The income approach, capitalization, is difficult to apply because income can fluctuate greatly and depend on many factors beyond the building itself. Question 31. In an open listing, a broker is entitled to a commission when the sale is made and she is its A. Listing broker B, procuring cause C, supervising broker D, none of the above. Correct answer is B, procuring cause. In an open listing, the broker who is the procuring cause of the sale earns the commission. Procuring cause means the broker's actions were the direct and primary reason the buyer purchased the property. It's more than just showing the property. The broker must have initiated the chain of events that led to the sale. Question 32. A telephone line crossing a property would probably be termed an A. Illegal encroachment. B. Appurtenant easement. C. Easement in gross. D. License. Correct answer is C. Easement in gross. An encroachment is when a structure or part of a structure physically intrudes onto another person's property. A telephone line, while crossing the property, usually doesn't constitute an encroachment in the traditional sense as it's generally above ground. An appurtenant easement benefits a specific piece of land, the dominant tenement, and is attached to that land. It runs with the land, meaning it transfers with ownership. A telephone line easement doesn't typically benefit a specific adjacent property. A license is a temporary and revocable permission to use another's land. An easement, on the other hand, is a right that typically lasts for a longer period and is often recorded, making it more permanent. An easement in gross is a right to use another person's land for a specific purpose, and it doesn't necessarily benefit a neighboring property. A telephone line crossing a property is a classic example. The telephone company has the right to use the land for the placement of the line, but it's not tied to their ownership of any adjacent land. Question 33. A void contract is A. Equivalent to a voidable contract. B. Can be ratified by the parties' mutual consent. C. May be ignored, with neither party having to take any further legal action. D. May be enforced by a court. Correct answer is C. May be ignored, with neither party having to take any further legal action. A voidable contract is one that can be enforced by one party, but can be rejected by the other. Example, contracts with minors. A void contract, on the other hand, cannot be enforced by either party. A void contract is completely unenforceable from its inception. It lacks one or more of the essential elements of a valid contract and has no legal effect. It's as if the contract never existed. Therefore, neither party is obligated to perform its terms, and no legal action is needed to nullify it further. A void contract cannot be ratified. Since it's missing essential elements from the start, simply agreeing to it later doesn't make it valid. It would need to be a completely new contract. A void contract has no legal effect, so a court will not enforce it. Question 34. The largest loan currently offered by the Department of Veterans Affairs, DVA, to qualified applicants making no down payment is A. $100,000, B. $150,000, C. $417,000, D. $1 million. Correct answer is C. $417,000. While the Department of Veterans Affairs, DVA, doesn't technically set a maximum loan amount, lenders typically cap no down payment VA loans at $417,000. This is due to secondary market limitations, meaning that lenders have difficulty selling loans above this amount on the secondary market. It's important to note that this limit can vary in high-cost areas. Additionally, veterans with full entitlement may be able to borrow more than $417,000, but they may be required to make a down payment. The purposes for which a DVA loan can be used include the purchase or construction of a home or business, home improvement or repairs, and the acquisition of a farm or farm equipment. Question 35. When an agency is established by estoppel, it can also be called an A. Ostensible agency. B. Express agency. C. Implied agency. D. Both A and C. Correct answer is D. Both A and C. Agency by estoppel is another term for ostensible agency or implied agency. It arises when a principal's actions or inaction lead a third party to reasonably believe that someone is their agent, even if no actual agency agreement exists. The principal is then estopped, prevented from denying the agency relationship. Express agency is created by a formal agreement, either written or oral,